Hey there, welcome back to yet another video in this series of videos which are making our life easy with regards to understanding the Design Act in the most simplest manner. In the last video, we discussed the rights, the copyrights that we can enjoy upon successful registration of our design. The copyright is valid for 10 years, which can further be extended by 5 years. Ever wondered what happens when you don't renew your design registration? So let's get into this session to understand what, why, and how of the same. As you can see, as per section 11.2, a copyright on design registration is valid for 10 years from the date of registration, which can further be extended by 5 years, provided you file a request for renewal using Form 3 as per section 11.2 and Rule 23. Form 3 to be filed before the expiry of initial 10 years for your application to be extended by another 5 years. If you do so, application gets extended by additional 5 years. What if you don't do? Simple, your design cease to have effect. What does it mean? It means that the copyright is no longer valid. You cannot stop anybody from using your design on any article. You don't have any legal rights. So that's not a good thing to have, isn't it? We can visualize this scenario from two sides. First, there could be a genuine reason that the applicant doesn't want to renew the registration any further. For business reasons, or the design may not be any longer relevant to the proprietor. Second case is where the proprietor forgot to renew the registration. He just missed it. So, do we have any option here? Think from the patent's point of view. Do we have any option when we don't pay the renewal fee on time? Yes, you guessed it right. We have the option to restore the application, isn't it? Similar, the case goes with design registration also. You have the option to restore the application. How do you do so? Let's have a look at it. As per section 12 and 13, restoration application has to be filed by the proprietor of the design within 12 months from the lapsed date when the design ceased to have effect. What form do we use? We use Form 4 as per Rule 24.1. We need to provide statement and evidences that led to we missing out on paying the renewal fee in good time frame. Once the controller receives the request from the applicant, the controller checks if a prima facie case has been made. If a prima facie case has not been made, then such an application, the Form 4 application, is rejected under Rule 24.2. The applicant has an option to request for a hearing with the controller within 1 month from receiving such a rejection from the controller. Rule 24.2. Controller provides for a hearing as per Rule 24.3, where arguments can be discussed orally, and applicant is provided with an opportunity to justify that the failure to pay the renewal fee was not intentional, basically. It was unintentional. Genuine loss, basically, or genuine lapse, if you can say that. If the controller is satisfied with the arguments made by the applicant and is convinced that the failure to pay was indeed unintentional, then the controller will allow the restoration of the application as per Rule 24.3. Once this has happened, applicant is required to pay the renewal fee, the unpaid fee which was not paid, and any additional fee, basically the penalty that needs to be paid for missing out on paying on time as per Rule 25.2. Once this is done, the design register is also updated with such details that the design has been restored and the reason for restoration as provided by the applicant. So with this, the applicant can again enjoy the copyright for the next 5 years. Now at this stage, you may have a question that what happens to the rights or what happens to the copyright during the period when the design had ceased to have effect and when the design was restored. Let's look into those cases. So here is a depiction for it. A period during which there was no copyright associated with the design registration, right? And there could be a case where few people would have started using or would have made arrangements or would have made investments to use the design, thinking that the design has no more copyright because it was not renewed. So what happens to these folks? Do the applicant have any rights to stop these guys who may have started availing themselves of the designs for their own use, for their own business purposes as well? Section 14 states that during such lapsed duration, there are no enforceable rights with the proprietor. Therefore, no suits or proceedings against any piracy or infringement can be instituted by the proprietor against the folks who may have started availing themselves of such lapsed design, thinking there is no enforceable right anymore. The controller may also come up with some provisions to protect the interest of such folks who may have made investments, may have made contracts, may have made arrangements to benefit from the designs. Be a reasonable deal with the proprietor once the design is restored. So with this, we are done with the session. We take away one important point with us that states that it's important for you to renew your registration on time for you to keep enjoying your copyright, because once it is lapsed, you don't have any rights and anybody can avail benefit of the design for their own purposes. We will continue with our journey with few more videos coming your way on leftover aspects of the Design Act, such as substitution of applicant or cancellation of registration and similarly others. Take care. Bye-bye.